Hello everyone. In this class we will be discussing the RTI Act 2005 and then Consumer Protection Act, Lokpal and Lokayukta, Public Service Delivery. These are the topics we will discussing this and the e-governance also. In last class we have discussed the Citizen Charter and Citizen Declaration. Or there would the Citizen Declaration and Citizen Charter are both the same topic, synonyms often associated with Citizen Charter is a formal voluntary document that acts as a commitment between the public and service organization and its citizens. It details services standards, quality, and service timeframes for delivery and grievance redressal mechanisms. In this class, we will study about RTI. The Right to Information RTI Act 2005 is a landmark legislation in India that empowers citizens to secure access to information under the control of public authorities, enacted to promote transparency, accountability. This the supremacy is the linchpin of abuse of power. Transparency is the only antidote. Greenwald. It is a phenomena of opening up functioning and of governments and its decision to the citizens. It enables the citizens to obtain information about government's decision making along with facts, figures, and mechanisms followed. Freedom of information, the core essence of transparency. Ensures accountability of governance, reduces corruption, abuse of power, increase the efficiency of government, opens up government activities into public scrutiny, corrects asymmetry of power between people and government, promotes public participation in governance, key realizing of other rights, helps in correcting trust deficiencies, can improve the quality and pace of decision making. Enacted to promote transparency, accountability, and contain corruption. It shifts governance from a culture of secrecy to openness. It is considered a crucial tool for a functional democracy and enabling an informed citizenry to vigilantly monitor governmental actions, achievements, and impact. The Act has revolutionized the government by allowing citizens to demand information without disclosing reasons. It has been instrumental in expensing major scandals like the 2G Spectrum and Commonwealth Games scams. Proactive disclosure section 4 has reduced the need for formal requests, while the 30-day timeline ensures accountability. It has strengthened participatory democracy, particularly at the grassroots level, by making governments record accessible challenges and limitations. Despite its success, the RTI Act faces significant challenges. There are high tendencies of appeals before information commissions, causing long delays in information delivery. There is a lack of awareness among rural populations. Legislatively, beginning the 2019 amendments to the Act, which authorized the central government to determine the tenure of and salaries of information commissioners, have raised concerns about the reduction of institutional independence. Further, the 2023 Digital Personal Data Protection Act DPDP Act amended restricts access to personal information, reducing the scope for public interest disclosures. Conclusion: the RTA Act 2005 is an essential tool for good governance, but its effectiveness is threatened by bureaucratic inertia and legislative dilutions. While it has achieved remarkable success in enabling public scrutiny, the future of the Act depends on protecting activists, enhancing the independence of information commissions, and strict adherence to the mandate of proactive disclosure. Consumer Protection Act. Then consumer. This is the website. All citizens have right to information. What can we do? Access, inspect work documents and records. Take notes, extracts, or certified copies of documents or records. Take certified samples or materials. Obtain information in the form of displays, floppies, tapes, video cassettes, in or any in form of electric mode through printouts. Section 2H from public authority. Constitutional bodies, statutory bodies, body owned, controlled, or substantially financed by government, including state-funded NGOs. The process: make a written request in English in the official language of the area, with fee and particular of the information sought in rupees 10 only. Section: the applicant shall not be required to give any reasoning for requesting the information. This is the website, sir. In this, we can fill the form. Time limit: information is to be provided within 30 days. 48 hours where life or liberty is involved. In 30 days only. The period can extend to 35 days where request is given to the Assistant Public Information Officers (APIO). Choosing a right conferred to citizens, choosing language of request, not stating any reasons for requesting information, assisting in accessing record. All fees are waived for below poverty line BPL applicants. Knowledge of reasons for rejection, making complaint to CIC and SIC. Obligations of public authorities: maintain all its records duly catalogued and indexed in a manner and form which facilitate the right to information and computerized within reasonable time. Publish within 120 days from the enactment of this act 16 types of information directory of officers' functions performed by them, category of document held by it, etc., and thereafter update these publications every year. Obligation of public authorities to provide as much information suo motu to the public through various means within 100 days of enactment designated to PIO in all administrative unit offices as may be necessary to transfer directed request within 5 days from the receipt of application. Where does one complain? The first appeal is made to an officer within the organization who is senior in the rank of to the PIO. The second appeal is made to the Information Commission. Central Information Commission. CIC, Chief Information Commissioner. Such number of central IC is not exceeding 10. Appointment by the President on the recommendation of committee consisting of Prime Minister, who shall be the chairman of the committee. Leader of opposition in the Lok Sabha, a union cabinet minister to be nominated by the Prime Minister. Qualification: CIC and IC shall be person of eminence in public life with wide knowledge and experience in law, science and technology, social service, management, journalism, mass media, administration, and governance. This shall not be an MP, MLA, or hold any other office of profit or connected with any political party or carrying any business or pursuing any profession. Conditions of service: 3 years, retirement 65 years, not eligible for reappointment. Through RTI Amendment Act 2019, the conditions of service are determined that Central Information Commission removal, proven misbehavior, incapacity, manner, is set to conduct an inquiry on a reference by President. It has transformed into grievance redressal tool, exposing scam collection, wasteful exploitation, set the trend of other rights based RTI application have been able to provide information to a large number of people. RTI enabling rights resemblance changes in after 2019 amendment. Problem of bureaucratic mindset, no specific budgetary application allocation for RTI by most departments. Lack of permanent citizens. Genuine activities in some cases have been replaced by blackmailers, resulting in filing of frivolous applications. Shallow awareness, lack of awareness in rural area. Opposition to those holding power to take responsibility and will be answerable for their behavior and actions. Now we shall be studying Consumer Protection Act. The Consumer Protection Act 2019, replacing the 1986 Act, is a landmark legislation in India designed to safeguard consumers' interests and establish authorities for timely settlements of disputes. It ensures fair trade practices and provides redressal against unfair trade practices, defective goods, and deficient services. The Act aims to empower consumers, particularly in the growing digital marketplace, by enforcing their rights. It provides redressal against unfair trade practices, defective goods, and deficient services. The Act outlines 6 core consumer rights: the right to safety, to be informed, to choose, to be heard, to seek redressal, and consumer education. Key features include Central Consumer Protection Authority, established to promote, protect, and enforce consumer rights, handling cases of misleading ads and unfair trade practices. 3-tier redressal machinery, quasi-judicial bodies at district, state, and national levels for foster simplified disputes resolution. E-commerce coverage, mandatory rules for online retailers to ensure transparency. Product liability, manufacturer, service providers, or sellers are liable to compensate for harm caused by defective products. Simplified procedure, consumers can file complaints electronically in a commission where they reside. And the Consumer Protection Act 2019 is a robust advancement, bridging gap in the digital age and shifting the ones to business to be more accountable. By empowering consumers to challenge exploitation, it cultivates a fair market environment. Ultimately, the Act serves as a helping hand to consumers, ensuring their protection through stricter penalties and proactive redressal. Now, after this, e-governance. Electronic governance or e-governance implies government functioning with the application of ICT, information and communication technology. Hence, e-governance is basically a move towards smart governance, simplifying simple, moral, accountable, responsive, and transparent governance. Application of ICT for providing governance services, exchange of information, transaction, integration of previously existing service and information portal. First major establishment of Department of Electronics, 1970. Smart governance, amplifying simple. What is smart governance? Simple. S means simple. implies simplification of rules and regulation of the government and avoiding complex processes with the application of ICT, and therefore providing a user-friendly government model. M stands for model meaning the emergence of new system in the administrative and political machinery with technology interventions to improve the efficiency of various government agencies accountable, develop effective information management system and other performance measurement mechanisms to ensure the accountability of public service functionaries, responsive, speed up processes by streamlining them, hence making the system more responsive, transparent, providing information in the public domain like websites or various portals, hence making functions and processes of the government transparent. Interactions in e-governance. There are 4 kinds of interactions of e-governance, namely government to citizens, government to government, government to business, government to employees. The G2C, government to citizens interaction between the government and the citizens. This enables citizens to benefit from efficient delivery of large range of public services, expands the accessibility and availability of government services, and also improves the quality of services. The primary aim is to make the government citizen friendly. G2B, government to business. It enables the business community to interact with the government by using e-governance tools. The objective is to cut red tapeism, which will save time and reduce operational costs. This will also create a more transparent business environment when dealing with the government. The G2B initiatives help in services such as licensing, procurement, permits, and revenue collection. G2C. G2G, government to government, enables seamless interaction between various government entities. This kind of interaction can be between various departments and agencies within government or between two governments like the union and state governments or between state governments. The primary aim is to increase efficiency, performance, and output. Read about government to government initiatives in the linked article. G2E, government to employees. This kind of interaction is between the government to its employees. ICT tools help in making this interaction fast and efficient and thus increases the satisfaction levels of employees. Advantages of e-governance. Improves delivery and efficiency of governance services. Improve government interactions with business and industry, citizen empowerment through access to information, more efficient government management, less corruption in the administration, increased transparency in the administration, greater convenience to citizens and business, cost reductions and revenue growth, increased legitimacy of government, flattens organizational structure, less hierarchy, reduces paperwork and red tapeism in the administrative processes, which results in better planning and coordination between different levels of government, improves relations between the public authorities and civil society by restructuring of administrative processes. Models of e-governance. Broadcasting model, critical flow model, comparative analysis model, e-mobilization model, interactive service model. Broadcasting model, dissemination of useful government information helps in correcting problems of information failure. Critical flow model, dissemination of relevant information to targeted audience. Challenge, limited vernacular content, information overload. Poor review and updation. Comparative analysis model, the concept is to assimilate best practices in the areas of governance and then use them as benchmarks to evaluate other governance practices. E-mobilization model, the concept is based on adding the opinions and concerns expressed by virtual communities. It creates a diversity of virtual communities, and the ideas, expertise, and resources are accumulated through this virtual form of networking. Interactive service model, it opens a venue for direct participation of individuals in governance processes. Under this model, the various services offered by the government becomes directly available to its citizens in an interactive manner. reduces delays in file processing, movement, etc. Multiple backups resulting in less risk of data loss, less paperwork, reduces requirement of manpower and space, cost cutting, improvement in service delivery. It facilitates government anytime, anywhere, reduces transaction cost, brings about greater transparency. It can facilitate greater democratic engagement. Some initiatives of e-governance regarding National E-Governance Plan, approved by central government in 2006, comprising approved by central government in 2000, comprises of 31 mission mode projects and eight components. Initiatives of Ministry of Electronic and Information Technology, inclusive of important sectors health, education, PDS, etc. NEGP brings all e-government efforts across the country under a unified vision goal to bring governmental sectors closer to citizens. E-Kranti, approved by Union Cabinet in 2015, it includes the vision, purpose, fundamental principles of E-Kranti, approach and methodology, program management structure and implementation strategy. Vision, transforming e-governance for transforming governance. Mission, to ensure a government-wide transformation by delivering government services electronically to the citizens through integrated and interoperable systems via multiple modes, ensuring efficiency, transparency, and reliability of such services at affordable cost. Objective, to achieve government-wide change by delivering government services electronically to citizens through integrated and interoperable system across different modes. It is intended to assure efficiency, transparency, and reliability of such services at affordable rates. Computerization of land records, government mobile seva, DISA, National Digital Literacy Mission, My Government in DigiLocker, in which we can save the documents, Umang app, e-district portal, e-seva Lokpani, Khajana project, the Friends, a one-stop shop for paying state taxes and other financial obligations. KV Sala Darpan, launched by Ministry of Human Resource Development in 2015. All Kendriya Vidyalaya can use KV Sala Darpan and e-governance platform. The platform uses information communication technology to improve academic delivery in all Kendriya Vidyalaya Sangathan institutions. Challenges are digital divide and digital trust. Problem of proper work plan development. Problem of narrow vision. Inadequacy of government process engineering. E-governments in India is largely stuck in the information dissemination strategies. Check on corruption and improvement in transparency have been more incidental and less intentional. E-governance is often seen as a panacea for all government is. National E-Governance Service Delivery Assessment. It aimed at providing the overall e-government development by evaluating the efficiency of service delivery mechanisms from a citizen's perspective. The index was based on 7 key parameters, namely accessibility, content availability, ease of use, information security and privacy, in service delivery, integrated service delivery, and status and request tracking. Public service delivery. Public service delivery. Public service delivery is the process by which governments provide essential services such as healthcare, education, sanitation, and infrastructure to meet citizens' basic needs and uphold our welfare. It enacts as the primary link between the citizen and states, between the state and citizens, where efficiency and transparency directly determine the public trust and governance quality. Key aspects of public service delivery. Essential services includes healthcare, is education, water supply, sanitation, public transport, and policing. Purpose ensures equitable access to necessary services, improves quality of life, and manages social infrastructure delivery mechanisms. Services are provided directly by government agencies via public-private partnership (PPP) or through local bodies, NGOs. Modernization of and e-governance initiatives like Digital India and Common Services Centers aim to improve efficiency, reduce corruption, and increase accessibility through digital platforms. Challenges and reforms. Bureaucratic hurdles. Conventional system often face inefficiencies, slow processes, and lack of accountability. Inclusivity issues, ensuring access to remote, rural, or marginalized populations remains a challenge. Reforms key improvement include adopting technology, example Aadhaar for authentication, increasing transparency, and strengthening as detailed in the open government partnership. Document citizen participation, public-private cooperation. Leveraging private sector strengthens will mitigating exploitation through regulation is a growing focus, as suggested by studies from the Indian Institute of Public Administration and the Asian Development Bank. Now Lokpal. The Lokpal and Lokayukta Act 2013. The Lokpal established under the Lokpal and Lokayukta Acts 2013 is India's apex statutory ombudsman, national level. Central or national level ombudsman. Tasked with It's a statutory ombudsman tasked with inquiring into corruption allegations against public functionaries, including the prime minister, ministers, and bureaucrats. It serves as a protector of the people, aimed at ensuring accountability, transparency, and integrity in public administration, functioning independently of the executive. Powers and functions. Investigate autonomy. Lokpal possesses powers of superintendence over central investigation agencies like the CBI for referred cases, including search and seizure capabilities. Jurisdiction. Covers groups A, B, C, D officers. Group A, Group B, Group C, Group D officers and top political leadership. Confiscation. It can recommend the attachment of assets procured through corruption. Preventive role. It can recommend policy changes to minimize corruption risks. Defects and suggested measures. Delayed operationalization. The Lokpal was constituted in 2019, 6 years after the Act. Measure mandate strict timelines for appointments. Toothless nature. Dependency. It relies on the CBI, CBC for investigation, limiting autonomy. The measure for this is establish an independent, specialized investigative wing. And low public trust. Procedural lapses are defect. Is also defect. High dismissal rates of complaints and a sharp drop in new filings. The solution measure for this is simplify complaints procedures and promote digital transparency. Exclusion of judiciary. The judiciary is outside its purview. The measures for this include higher judiciary under ethical scrutiny, role in redressal of public grievances, will primarily anti-corruption local contributes to grievances redressal by tackling systemic corruption that causes public distress. Example, in welfare schemes, it holds public servants accountable, enhancing administrative responsiveness through although it is not a direct complaint portal for routine service delays. Conclusion, the local is a landmark yet underdeveloped institutions in India. India's anti-corruption framework to become an effective ombudsman, it requires greater financial, administrative, and legal independence, alongside a shift from procedural rigidity to substantial justice, ensuring its role as a true moral senator of democracy. Lokayukta state level ombudsman. The Lokayukta is an anti-corruption ombudsman institution at the state level in India, introduced to investigate allegations of corruption, maladministration, and misuse of powers by public servants. Rooted in the recommendations of the Administrative Reforms Commission 1966 to 70 and mandatory under the Lokpal and Lokayukta Act 2013, it acts as a safeguard for public integrity, primarily addressing complaints against ministers, MLAs, and bureaucrats. Powers and functions. Lokayuktas possess quasi-judicial powers, including the power to investigate, conduct independent investigations into allegations of corruption, search and seizure, authorize search and seizure of assets suspected to be acquired through corruption, recommend action, suggest disciplinary proceedings, transfer or suspension of corrupt public servants to the competent authority, grievance redressal, address public grievances regarding administrative injustice, delay, or negligence, contempt powers. In some states, they possess the power to punish for contempt. Role in public grievance redressal. The Lokayukta is not just an anti-corruption agency, but also a key mechanism for redressal of public grievances arising from administrative lapses. It acts upon complaints from citizens regarding nepotism, favoritism, and neglect of duty. Neglect of duty by officers acting as bridge between the citizen and the state to ensure good governance, defects and measures to improve. Despite its intended role, the institutions face challenges. Weak teeth. Recommendations are often advisory, not binding on the state government. Lack of autonomy. Dependence on state-controlled agencies for investigations. Non-uniformity. Varying state laws lead to different jurisdictions. Example, some include the chief minister, others exclude. Suggested measures. Uniformity enact mandatory central guidelines to make the Lokayukta structure uniform across all states. Independent investigative wing. Provide the institution with its own independent police or investigative staff. Binding recommendations. Make the findings and recommendations binding on the government. Strengthening autonomy. Ensure independent appointment processes, minimizing political interference. Conclusion, the Lokayukta is a crucial pillar for accountability in the state administration. By strengthening its investigative powers, ensuring financial autonomy, and making its recommendation binding, the institution and can become more effective, thereby fostering transparent, efficient, and corruption-free governance in India. It seeks to provide the establishment local for union Lokayukta for state to inquire into allegations of corruption against certain public for related matters. Lokpal 1809 Institution of Ombudsman inaugurated officially in Sweden. 1962 New Zealand and Norway adopted this system. 1916 adopted by UK. In 1966 Guyana became the first developing nation to adopt the concept of ombudsman. Subsequently it was further adopted by Mauritius, Singapore, Malaysia and India as well. In India, first proposed by Ashok Kumar Sen, Law Minister in the early 1960s. The term Lokpal and Lokayukta were coined by Dr. L.M. Singhvi. In 1966, first ARC, in 2002 NCRWC, and in 2005 second ARC recommended the setting up of two independent authorities. Till 2011, 8 attempts were made to pass the bill, but all met with failure. India Against Corruption movement led by Anna Hazare pressurized the central government into passing the Lokpal and Lokayukta Bill 2013 in both the houses of parliament. It received assent from President on January 1, 2004 and came into force on 16th January 2014. Rules and format for filing complaints with Lokpal were issued in March 2020. Lokpal composition: multi-member body, one chairperson and maximum 8 other members. Other members include judicial and non-judicial members. Other maximum 8 members, half will be judicial members. Minimum 50% of the members will be from SC, ST, OBC minorities and women. Qualification: chairman. Former Chief Justice of India, former Judge of Supreme Court, an eminent person with impeccable integrity and outstanding ability, having special knowledge and expired of minimum 25 years in the matters of relating to anti-corruption policy administration, vigilance, financing, includes insurance and bank law and management. Qualification: former Judge of the Supreme Court or former Chief Justice of High Court. Qualification: non-judicial member, an eminent person with impeccable integrity and outstanding ability, have special knowledge and expertise of in matters relating to anti-corruption policy, public administration, vigilance, financial, including insurance, bank law and management. Appointment by President. On the recommendation of a selection committee consisting of Prime Minister, Chairman, Speaker of Lok Sabha, appointed by the Lokpal is appointed by President, consisting of Prime Minister, Speaker, Leader of Opposition of Lok Sabha, Chief Justice of India, Supreme Court judge, SC judge, one eminent jurist. Terms of office 5 years till the age of 70 years. The salary allowance and other conditions of service of person are equivalent to Chief Justice of India. Members are equivalent to Judge of Supreme Court. Removal by President on grounds of misbehavior after presidential reference to Supreme Court on petition signed by 100 MPs. Prime Minister of India under certain conditions. Member jurisdiction: member of Parliament Group C and Group D officials, all ministers of Union Group A and Group B officers, any person who has been in charge, director, manager, secretary of any bodies set up control financed by central government. The power: it has powers to superintend over and give direction to CBI, powers to authorize CBI for search and seizure operations connected to such cases. It has referred to case to CBI, the investigating officer in such case cannot be transferred without approval of Lokpal. The inquiry wing of the Lokpal has been vested with the powers of a civil court. Lokpal has powers of confiscation of assets, proceeds, receipts and benefits arising or procured by means of corruption. Lokpal has powers to recommend transfer of suspension or of public servant connected with the allegation of corruption. Lokpal has power to give direction to prevent destruction of records during preliminary inquiry. Limitation: Lokpal will not entertain any complaint if the complaint is related to an offence committed as back as 7 years or more. No protection to whistleblowers. Judiciary is not subject to Lokpal jurisdiction. Lokpal cannot conduct inquiry against itself. Lokpal will not inquire the PM if the allegation of corruption is related to international relations, external and internal security, public order, atomic energy and space. Further, allegation against Prime Minister can be taken up for inquiry only when the two conditions as follows are satisfied. full bench of the Lokpal consisting of its chairperson and all members considers the initiation of inquiry. At least two-thirds of its members approve such inquiry. Such inquiry against the Prime Minister will be done in camera. If the local concludes that the allegation is false and the inquiry should be dismissed, the records of the inquiry shall not be published or made available to anyone. Lokayukta institution of Lokayukta was first established in Maharashtra in 1917 through Odisha had passed the act in the regard to 1970. Some states created the Lokayukta as well as Up Lokayukta, like Rajasthan, Karnataka, Andhra Pradesh, and Maharashtra. But no specific collection are specified in the states of Bihar, Maharashtra, and Rajasthan. Majority of the states like Bihar, Punjab, Tamil Nadu, West Bengal, and Himachal Pradesh have created only the Lokayukta. There being no provision for Upa Lokayukta. Judicial collection prescribed by the Lokayukta in the states of Uttar Pradesh, Andhra Pradesh, Gujarat, Odisha, Karnataka, and Assam. Tenure of 5 years, duration is 65 years of age. In most, the term of office fixed for Lokayukta is 5 years, duration of or 65 years of age, whichever is earlier. He is not eligible for reappointment for a second term. No reappointment. In most of the states, the Lokayukta can initiate investigation either on the basis of complaint received from the citizen against unfair administrative actions or suo motu. However, they do not enjoy the power to start investigations suo motu in the states of Uttar Pradesh, Himachal Pradesh, and Assam. The Lokayukta can consider the cases grievances as well as allegations of corruption in the state of Maharashtra, Uttar Pradesh, Assam, Bihar, and Karnataka. But in Himachal Pradesh, Andhra Pradesh, Rajasthan, and Gujarat, the job of Lokayukta is confined to investigations on corruption, not grievances. Thank you, everyone.